Good morning and welcome to this morning's Cornerstone webinar on the Court of Appeal decision in London Borough of Barking and Dagenham and persons unknown and pretty much every other local authority up and down the country. I'm Ranjit Bhose and my co-presenter is Wayne Beglan, who you can see on the slide. And if you go to the next slide, you'll see the title of our talk, a very funny joke, thank you. And then the next slide is two lovely photographs of us. You can please feel free to use those as your screensavers if you wish. You can see that I have gained weight. Wayne has lost weight, lost hair, but remains younger than me, and so I remain bitter and twisted. So next slide, let's get on with the show. So I set out here the central question that arises in the Court of Appeal litigation, but I thought it'd be better first to set out some context for the persons unknown injunctions sought by Barking and many other local authorities, and how and why the matter came before the Court of Appeal. Now, in the last decade, if not earlier, many local authorities have been concerned about the risks of public land, whether that be green space, parks, commons, or car parks, being occupied by persons unknown for residential purposes, sometimes for days or weeks, sometimes even longer. And those concerns were based on actual incursions that individual authorities had suffered over the previous years. And the mere fact of incursion was compounded by the fact that such occupation was sometimes accompanied by nuisance and waste being left, particularly when the persons unknown moved on. And it could also be commercial tipping. The cleanup costs could be very high, quite apart from the land being unavailable for members of the public to enjoy during those periods. And it is right to note that the focus of many local authorities' concerns was principally members of the travelling community. And in fact, in the High Court, in the Barking litigation, the injunctions sought and obtained were referred to as traveller injunctions. Now, the authorities considered that the best fitted remedy to seek to deal with this problem was a quia timid injunction, an injunction to restrain against threatened wrongs, whether that be trespass to land, nuisance, public or private, or apprehended breaches of planning control under Section 187B of the 1990 Town and Country Planning Act. And not least, this is because injunctions backed by the power to commit and the remedies on committal have been shown to work. They have a clear deterrent effect. There was, however, a particular challenge in these group of cases. Ordinarily, the authorities did not know the identity of the persons unknown who may in the future commit the wrongs that they were seeking to prevent. They may know a few people based upon previous incursions, but that tended to be the exception rather than the rule. And that challenge was compounded by the fact that the persons unknown on one particular piece of land would be different to those on another, and that different persons unknown would come to different pieces of land at different times, often stretching some months or years into the future. And so it was self-evident that for injunctions to be effective, whether interim or final, they had to apply to any person unknown whenever they came to the land, any of the pieces of land. And that included what has now been termed newcomers, namely those persons unknown who come to the land in question after a final injunction has been granted in the proceedings and therefore have no knowledge, or at least no provable knowledge, of the proceedings or the final order before they arrive at the land, and certainly haven't been served with any papers. So newcomers are not parties in the established civil litigation case sense. They haven't had the opportunity prior to the grant of the final injunction to challenge whether it should be granted against them, and if so, in what terms. However, it's right to note that a series of High Court and County Court judges have been content to grant final injunctions that did, at least on their face, purport to apply to newcomers. And it's also right to note that there have been committals for contempt against newcomers where no one whether the court or those representing the newcomer have taken any issue with the question of whether or not the final injunction bound them. However, the law took a turn with the Canada Goose litigation in 2019-2020. In that case, final quia timid injunctive relief was sought to restrain protests outside Canada Goose's shop on Regent Street, and Canada Goose said that such an order would bind newcomers. The Court of Appeal in that litigation said no. It upheld the first instance judge and said that final injunctions do not bind newcomers in protester cases. Only those who have been served and have become parties by the final hearing are capable of being bound. Now, again, it's right to note there was no immediate appreciation that the ratio of Canada Goose applied to traveller injunctions. In fact, there were a couple of cases post-dating it where High Court judges considered the Canada Goose didn't apply. But matters changed in October 2020 when the London Borough of Enfield sought a traveller injunction in the High Court. They sought only an interim injunction, but because they intended to press on for a final injunction, the issues in Canada Goose arose. And that application came before Mr. Justice Nicklin, who had also been the first instance judge in Canada Goose. He had a number of concerns about traveller injunctions generally, and also about their binding newcomers. And he then proceeded to gather together some 38 claims called the cohort claims, where different High Court and County Court judges up and down the country had granted final or interim relief in traveller claims and sought to case manage them. He then determined there were to be a series of preliminary questions to be tried, and in May of last year, in a judgment, a pithy 250-odd paragraphs, held that final injunctions cannot be granted so as to bind newcomers in traveller injunction cases. And the logic of his decision there also meant, in effect, that no interim relief was available either. Faced with that judgment, a number of the authorities appealed to the Court of Appeal. That appeal was heard in December of last year, and judgment was handed down last week. And the central question, as set on the slide, is whether the judge was right to hold that the court cannot grant final injunctions that prevent persons who are both unknown and unidentified at the date of the final order, i.e. newcomers, from occupying and trespassing on local authority land. And the Court of Appeal held unanimously that the judge was wrong so to hold. The court may grant such orders, and in doing so, the court declined to follow the Canada Goose decision the previous year. The only judgment in our case was given by the Master of the Rolls to Geoffrey Voss. And what we propose to do in this webinar is explain the background to and some of the facets of the person's unknown injunction jurisdiction, to deal with barking at first instance and on appeal, and then to explain the consequences of the appeal. And I should say that this recording will be available on our website shortly, and there is also a chat function on the webinar. If you do have questions, we'll try and answer them in writing as we go, Wayne now and then me later. And if there's time at the end, then we'll also try to deal with a couple orally. But I'm afraid we do have a fair amount to get through, and barristers' time estimates are notoriously optimistic. So if we don't get to any oral questions, please blame Wayne. Next slide, please. I should also say that Wayne is dealing with the slides because I'm technically incompetent. So the next slide is the wider dimension, because it's right to say that the consequences both of the first instance decision and also the appeal decision are clearly not limited to injunctions against travellers, and nor are they limited to claims brought by local authority claimants, but they apply also where one has private landowners. And so set out here a number of other areas where this same issue arises. One is car cruising injunctions, a number of those obtained in the Midlands by Midlands authorities, where car cruising and the risks that it provides to members of the community is a real and pressing problem. Also, injunctions to restrain raves and other nuisances on land. During lockdown, there were a series of cases where authorities sought to get injunctive relief because of breach of COVID restrictions. And then there are injunctions granted to restrain protests, both in the public and private sector. And two of the cases before the Court of Appeal, Ineos and Quadrilla, were private sector fracking cases. Then more basic claims by a private landowner to restrain a threatened trespass to their land, and urban exploring injunctions. Those injunctions sought to stop persons unknown from climbing the Shard or climbing up the stadium at Stamford Bridge. Yes, they do it. And finally, injunctions to restrain breaches of planning control under 187B, where those in the frame are not travellers. So it applies to a wide range of other issues, and we'll touch upon those later in the webinar. Move to the next slide, please. Should say here a note on terminology. The Master of the Rolls was very clear in saying that one shouldn't use Latin tags in this area, particularly inappropriate. And so we should find other terms to use it. And so a quia timid injunction should be referred to as a precautionary injunction, and an injunction contra mundum should be an injunction against the world. And I'm pleased to see that this new form of terminology and changed words has extended as far as Downing Street. Move on now, please, Wayne. So how do we get here? The old approach to persons unknown injunctions would be generally to describe the persons as persons unknown some years back, to obtain orders for alternative service under Rule 615 by erecting notices on the land or on a website, but sometimes not complying with the other parts of 615, which make provision for when proceedings are deemed to be served, etc. Interim injunctions often, indeed almost invariably, granted without notice. Then no defendants attending at any final hearing. Again, orders made for alternative service on the final injunction, and then a general assumption that everyone was bound by the final injunction. And it's right to say that there wasn't a great deal of concern about how one approached alternative service, how one described the persons unknown, or the fact that who would be bound. It's simply how things were done. But then, next slide, please, we have in the last 3 or 4 years had a series of higher court cases, one in the Supreme Court and 5 Court of Appeal cases, which touch on this issue. Now, the first of those on the slide, Cameron, that's the Supreme Court case. That wasn't, in fact, an injunction case at all. What it was a case where a claimant sought to amend her claim form to sue a hit-and-run driver for negligence to claim damages. And the amendment sought was to sue a person described as person X who was driving car Y on certain date who crashed into my car. And the Supreme Court held that one could not sue a person such as that. It was not permissible. It would be impossible to effect service on that person because they're being defined by their previous acts. And it was wrong in principle to dispense with service. So a very different case, a very weighty judgment by Lord Sumption, but it then became the bedrock for what happened in Canada Goose. As to the other 5 cases on the slide, Ineos and Quadrilla Boland, as I've already said, they were both private sector fracking cases to restrain protests. Bromley was in fact a traveller injunction case where the court gave general guidance on how such injunctions should be sought and what safeguards the court should impose, but didn't question the grant of final relief against newcomers. And Wayne will in due course deal with the general guidance given there in the light of what was said in Barking. And then we have Canada Goose, and finally our litigation, Barking and Dagenham, the cohort claims. Next slide, please. But before we get expressly to the cases and the particular litigation we're dealing with, I think it's probably better to deal with 3 matters of relevance in this jurisdiction. And they are, firstly, how are persons unknown in this jurisdiction to be described in the claim form as potential defendants? Secondly, how does one deal with issues of service of the claim form against persons unknown? And thirdly, how does a person become a party to the proceedings between issue of the claim and final hearing? So as the first point, the description requirement. Obviously, where the person unknown is known by sight, by photograph, or by occupation of land, or by ownership of vehicle, then they should be described by reference to whatever the claimant has. But there are other cases where the person unknown is not known and can't be identified because they haven't yet come to the land in question, but they are or may be one of a class that the claimant fears may do so in future. And here it's been confirmed in INEOS that it's permissible to describe persons unknown defendants by reference to future unlawful acts which the claimant considers they will or are likely to commit. And INEOS said there's no conceptual impossibility in suing persons by reference to future unlawful conduct. And so, for example, in the claim form, the persons unknown must be described by reference to conduct which is alleged to be unlawful. It's Canada Goose. For example, persons unknown entering or remaining without the consent of the claimant on land and buildings shown edged reg on the plan's annex amended claim form, i.e. trespassers. What you cannot do is simply refer to defendants as persons unknown or persons unknown occupying land, because on its face, those definitions would embrace every householder in England and Wales. Rather, there is a need to describe the persons unknown extremely carefully. And furthermore, they must be described carefully and also by reference to unlawful conduct. But there are some cases we'll look at in Canada Goose where some lawful conduct may be the subject of the description requirement. But one has to look very carefully at what the law requires in INEOS and Canada Goose. Next slide, please. The second point deals with service, the claim form. And a couple of judgments here from Lord Sumption in the Supreme Court, which have apply generally, but not so much in our area as the Court of Appeal has said. What he said in Barton and Wright Hassel is the court generally acts in persona. That term wouldn't survive the Master of the Rolls statement in Barking. An action is completely constituted when the claim form is issued, but it's not until there is service on the defendant they become subject to the court's jurisdiction. And that theme was followed on in Cameron, where Lord Sumption made a very general statement of principle. It's a fundamental principle of justice that a person cannot be made subject to the jurisdiction of the court without having such notice of the proceedings as will enable him to be heard. And what he said is that subject to any statutory exception, it's an essential requirement for any form of alternative service under Rule 615 that the mode of service should be such as can reasonably be expected to bring the proceedings to the attention of the defendant. And that was latched onto by Mr. Justice Nicklin in Barking, in doubting whether it is ever possible to devise appropriate provisions for alternative service in traveller claims. And although, of course, there is power under Order 616 to dispense with service, in Cameron, Lord Sumption said that it is very hard to envisage circumstances where the court would do that, where there is no reason to believe that the defendant is unaware, it should be that. And there's no reason to believe the defendant is aware of the proceedings, that's right. So it's a very narrow jurisdiction. And then the third point, next slide, please, Wayne, is how does a person unknown become party to proceedings? So what do you do if you have an interim injunction against persons unknown, which describes them by reference to future unlawful acts? Someone then comes along and engages in the acts themselves. How do they become a party? And that question was answered in the Gamma litigation in 2006 in the Court of Appeal. There, the court had granted an interim injunction in September 2004 against persons unknown causing or permitting caravans, mobile homes to be stationed on land known as. The order made provision for alternative service of the claim form and the interim injunction. Some months later, Mrs. Gamble moved on to the land with her caravan. The terms of the injunction were communicated to her the next day, a few days later. And so from that point, she was in breach of the interim injunction. Injunction made, description requirement applies to her, she breaches, therefore in breach. And she also became party to the proceedings by virtue of the order for alternative service of the claim form having been made, and her commission of the acts which the interim injunction prevented, therefore bringing herself within the class of defendant. And that's been held to be called the Gamble principle. Next slide, please, Wayne. However, there is a couple of points to note about this. A person unknown doesn't become a party to proceedings simply because an order for alternative service of the claim form has been made against them. Because without more, they have not brought themselves within the description of the defendant, which is defined by reference to future unlawful acts. Therefore, what they have to do is commit acts which breach the description requirement, therefore bring themselves within the category of defendant in the claim form. Next slide, please. That brings us then to Canada Goose. And Canada Goose are the well-known purveyors of luxury goods that use real fur and down. And they suffered a series of protests on Regent Street outside their flagship store. And they brought proceedings seeking a precautionary injunction against persons unknown. Their application for summary judgment was refused by Mr. Justice Nickley, who also said in the course of his judgment that even had judgment been available, it could not have bound newcomers. He relied heavily on the principles of Lord Sumption in Cameron. Canada Goose's appeal to the Court of Appeal was dismissed, and it analysed the cases of Gamble and Ineos, and also Lord Sumption's statements in Cameron, and then made a very general statement of principle in paragraph 89. This was that a final injunction cannot be granted in a protester case against persons unknown who are not parties at the date of the final order, i.e. newcomers who have not by that date committed the prohibited acts and do not fall within the description of the persons unknown and who haven't been served with the claim form. It recognised that there are some very limited circumstances where an injunction can be granted against the world. Those cases are really ones only where the need for an injunction must be met, is because the court, being a public authority under the Human Rights Act, in order to comply with its own obligations under Section 6 and to protect the convention rights of the claimants, must grant an injunction. And so Venables and News Group was an application by the killers of Jamie Bulger, who wanted lifetime anonymity orders and injunctions preventing their new identities or locations from being publicised. And similarly, in Mary Bell, another child killer, she also obtained such an injunction. And the basis for those claims, as the courts have explained, is that the Article 3 rights of the claimants are such that if the court does not grant such injunction against the world restraining publication, then they are at risk of serious injury or death. So it is a very, very narrow jurisdiction. And the Court of Appeal said the protester actions don't fall within that exceptional category. Rather, the usual principle applies. A final injunction only operates between the parties to the proceedings. And for good measure, bookending, that's consistent with the fundamental principle in Cameron. You can't be made subject to the court's jurisdiction without having had notice and being able to be heard. Next slide, please. So that was Canada Goose. And as I say, it's fair to say it wasn't easily appreciated that what the Court of Appeal said there in relation to protester cases applied equally across the board. But matters, as I say, took a turn in the autumn of 2020 when the judge brought into one cohort some 38 sets of proceedings and then case managed them. In those claims, the defendants were generally described as persons unknown, some by reference to occupation of land, some by reference to persons unknown depositing waste. And the claims across the gamut of the authorities relied upon trespass, public and private nuisance, section 187B, and section 222 for threatened breaches of the criminal law, principally public nuisance. And there were also some reliance upon section 130 of the Highways Act, obstruction, and section 1 of the 2014 Act concerning antisocial behaviour. Now, along the way, because of the way in which the case was case managed, a number of the authorities' claims fell away and were dismissed because of problems with service and the like. But some remained, both final and interim injunctions, and they went on to be determined at the preliminary hearing before the judge. Next slide, please. And the question that he asked in particular was whether the court has jurisdiction and or whether it is correct in principle generally or in any relevant category of claim to grant a claimant local authority final injunctive relief against either persons unknown who are not, by the date of the hearing or the application for the final injunction, persons whom the law regards as parties to the proceedings and or on a contra mundum basis. So can you slip it inside the very, very narrow Venables jurisdiction? And the judge held that the court has power to grant injunctions that bind non-parties. Contra mundum injunctions are granted under section 37, but that it would be wrong in principle to grant such injunctions in traveller cases. Those injunctions are subject to the principle that a final injunction only binds the parties to the action, i.e. the trial defendants. Newcomers are not bound. And he also rejected the argument that a newcomer becomes a party simply by breaching the terms of a final injunction. Rather, as he so held, that injunction simply doesn't apply to him. And unsurprisingly, travel injunctions don't fall within the contra mundum jurisdiction. And indeed, it's right to say the authorities hadn't really relied upon that, but for good measure, points are made in case the matter would go further. Next slide, please. So the consequences for the authorities were, of course, stark. Final injunctions could bind only those persons unknown who the claimant could identify, whether by name or photograph, and demonstrate had become a defendant of the proceedings before the grant of the final injunction, i.e. those who had both been served by alternative service and had also committed acts which resulted in their becoming defendants. So it applied only to a handful of people in some cases and none in others. So fairly damning. And secondly, so far as interim injunctions had been granted, what the judge held is that if they wanted to maintain their claims, they would have to identify the persons who had since the grant of the injunction become a defendant and then case manage on swiftly to a final hearing. And the trial would therefore be only against those individuals. So the upshot was that injunctive relief that had been sought to obtained to protect against all persons unknown in the future was reduced to applying only to those who, having been served with the claim form, were so stupid or willful as to breach the injunction to bring themselves within the defendant. And so injunctions which had been sought to protect against rights and had worked because people hadn't been breaching them were simply brushed away by the judge and this judgment. Next slide, please. Unsurprisingly, therefore, there was an appeal to the Court of Appeal, and there were three charities representing the traveller community who intervened to support the judgment of first instance, and the court also appointed an advocate to assist it on the law. And the Court of Appeal, as you know, allowed the appeal, and it didn't do so by distinguishing Canada Goose and limiting it to protester cases only. It was not attracted to that line of argument. It didn't see there was any proper distinction to be drawn between protester cases on the one hand and trespass claims on the other. And of course, the two may be the same. Rather, it sought to allow the appeal on a more fundamental basis and declined to follow Canada Goose. We've set a series of points on this slide and the next as to what the Court of Appeal decided. First, it held, which was common ground, the court has power under Section 37 of the 1981 Act to grant an injunction that binds non-parties to the proceedings. Secondly, that is a broad provision. The court shouldn't cut down its breadth by imposing limitations which may tie a future court's hands in types of cases that cannot be now predicted. The court very sensibly taking the view that the point about the common law is to adapt and mould to change circumstance, and that is what Section 37 enables one to do. Thirdly, it held the judge was wrong to regard a final injunction as a remedy flowing from the final determination of rights between the claimants and the trial defendants. It said there is no fundamental difference between the two. Indeed, in the cases of injunctions granted against persons unknown, there is no real distinction. And the court analysed Gamel and what was said about it in Ineos and accepted that injunctions, whether interim or final, may validly be granted against newcomers. Next slide, please. And went on to hold the effect of Gamel is that a newcomer who knowingly violates the terms of an injunction, whether interim or final, automatically becomes a party by their act of violation. Now, that would have been all very well, but for the fact that one had Canada Goose in the way and Cameron. And the Court of Appeal held that Canada Goose was inconsistent with both Gamel and Ineos, and applying the doctrine of precedent, it concluded it was entitled to follow Gamel and not Canada Goose. It went on to say the judge below had been wrong to follow Canada Goose and had misunderstood Cameron, and he should have applied Gamel, Ineos, and Bromley. So ultimately, therefore, the appeal was allowed, and the court recognised that final injunctions can be granted against newcomers in traveller cases. The court then made a few other general points. It said that these sorts of final injunctions may also be appropriate in other cases, and it referred in particular to some protester cases, but said it would be inappropriate to lay down further limitations. And that's consistent with what it said about the breadth of Section 37 and not tying future courts' hands. And although it went on to say that such cases are certainly exceptional, that doesn't mean that other categories may not in future be shown to be proportionate and justified. And it fastened upon the urban exploring injunctions as an example of a novel situation where such relief was shown to be required. And then finally, it dealt with Section 187B and in effect said that the same principles apply under 187B and Section 37. So the power to grant final injunctions against newcomers under Section 187B is no less as broad as under Section 37. Now, I think a question just popped up on the slide. It is right to say an application for permission to appeal has been made by the interveners. That has been opposed by the local authority respondents, and the Court of Appeal will, I would imagine, in the next few days, give its determination whether or not permission to appeal to the Supreme Court should be granted. If permission is refused, I suspect that a fresh application will be made to the Supreme Court, but we will let you know in due course. Move on then, please, Wayne. So, in terms of consequences, what the Court of Appeal has done has restored the position to what many had assumed to have been the case before the Canada Goose litigation and the decision at Barking at first instance. As to the consequences, well, I mean, there are firstly consequences for interim injunctions, which go to matters of practice and procedure. There are consequences for non-traveller injunctions, which I'll deal with in a moment. And there are consequences for traveller injunctions, including the guidance given in Bromley, which Wayne will deal with, And also there are consequences for non-traveller Section 187B injunctions. Now, dealing first with the interim stage, the court in Barking noted the Canada Goose guidelines for interim injunctions. It didn't revisit them in detail. In fact, no real argument was expressed towards them. And it seems to us, therefore, they remain good law, say that it is necessary to modify them in a couple of respects because of what was said in Barking. So a series of points here. Firstly, the persons unknown defendants are by definition persons who have not been identified at the time of the commencement of the proceedings. If along the way they become known, whether by name or description, they must be joined as individual defendants. Otherwise, they can remain as with the description requirement, but there must be alternative service provision made for them. Now, there is a slight gloss on this because in Barking, it was said that a normal procedural approach should apply to the progress of the Part 8 claim, bearing in mind the importance of serving the proceedings on those affected and giving notice of them so far as possible to newcomers. So it didn't actually say how one would give notice to newcomers, particularly after final injunctions, but Wayne, I think, will deal with that when he says his piece. That's the first point. Move on, please. Next slide, please. Secondly, as I've already said, the description requirement is important. You must define the persons by reference to the conduct alleged to be unlawful. Thirdly, the standard test for interim injunctive relief in a precautionary setting, namely there must be a sufficiently real and imminent risk of a tort or wrong being committed to justify preventative injunctive relief. And then I'll pass over 4. And then as to 5, the prohibited acts must correspond to the threatened tort. So when your description requirement must relate only to to unlawful acts. However, when it comes to the interim injunction itself, it may, in certain circumstances, be permissible to prevent conduct that is lawful. And what the Court of Appeal in Canada Goose particularly had in mind is where it is necessary to protect a claimant's proprietary rights to impose an exclusion zone around their land. Although moving into land which wasn't owned by them wouldn't be a trespass, if it is necessary to protect their rights, then the court has power to order an exclusion zone. Next slide, please. And the last couple of points. In terms of the terms of the injunction, they must be clear and precise so that the persons affected know what they must and must not do. That should be law school stuff. And that because you are dealing with injunctions to be enforced against lay persons, you mustn't describe the acts by reference to legal causes of action. So you shouldn't use terms such as trespass, harassment, or nuisance. You should be more careful than that. And also, when you're describing an injunction, you shouldn't refer, unless you absolutely have to the defendant's intention. You should avoid doing that. Then the final point from Canada Goose is that the interim injunction should have clear geographical limits and it must be time limited because it's an interim and not a final injunction. However, on that point, it's right to say that in Barking, the Court of Appeal said there is no rule that an interim injunction can only be granted for any particular period of time. And this was in response to a direction of the judge below that, in his view, whenever a traveller claim is sought and an interim injunction is granted, the court should then give very short directions, looking to have a final hearing in about a month or 2 months. The Court of Appeal did not agree with that. Next slide, please. So that's the consequences for interim relief. And my final slide concerns with consequences for other cases. Dealing first with car cruising injunctions, it seems to me that these should again be available. And indeed, a car cruising injunction in Sharif was described as a classic case for the grant of an injunction. And I don't think that many issues will arise there. Secondly, so far as concerns injunctions to restrain raves and other nuisances on land, again, they should now be available, always depending upon the evidence, but care needs to be taken, to focus only on unlawful activity. It can be very difficult when you're dealing with raves or these sorts of nuisances only to encapsulate unlawful activity where issues such as noise or other behaviour is concerned. And you really need to err on the side of caution, otherwise the court will have an issue with that. Then, so far as injunctions to restrain protests, these remain a little more problematic because of the rights under Articles 10 and 11 to protest, but injunctions were granted in Ineos and Quadrilla, and the Court of Appeal in Barking didn't dissent from the proposition that they may be granted in future. And it would seem to me that where the landowner is a private entity and not a public authority, the scope for gaining that sort of relief is greater, although one again has to be very careful in describing the defendants and then what conduct is prohibited. Moving on penultimately to private landowner injunctions to restrain other trespasses. Again, I think these are in principle available. It is very difficult to see what is wrong with granting an injunction against newcomers to stop people clambering up and down large buildings in London. And then the final point is injunctions to restrain antisocial behaviour under Section 1 of the Antisocial Behaviour, Crime and Policing Act 2014. Nothing about the Court of Appeal's judgment affects this. Those injunctions are not available. Section 1 of that Act only envisages the grant of an injunction against an identified person, not persons unknown. That was so held at first instance in Barking. It wasn't appealed because it's clearly correct, and therefore one can't rely upon that. Wayne.
Thank you, Ranjit. And building on what Ranjit's taken us through, I'm going to deal with three specific issues in the time remaining within the webinar. The first is to look at some of the issues that have arisen in final traveller injunctions, so defined, and of course they have a very specific definition within the Barking case. The second is to look at some issues in relation to service, but more specifically with regard to Gypsy and traveller injunctions in relation to individual sites rather than those against the world, as it were. And then thirdly, to look a bit more specifically at some of the issues that have been troubling the courts in relation to Section 187B planning injunctions, but bearing in mind the important observations that we now have from the Court of Appeal in dealing with the broader injunctions. And people will need to bear with me just a little while I operate the slides at the same time as making my way through my notes. So first of all, a few slides dealing with the final traveller injunctions and what the correct approach will be going forward. The first point to note in relation to the guidance that had earlier been given by Lord Justice Coulson in the Bromley case is that the Court of Appeal in our case offered guidance about the continuing correctness or otherwise of a number of those observations. And it's important to bear in mind the basis upon which the Court of Appeal departed from what had been said by way of general guidance in the case of Bromley. And the first basis for the departure was to recognise, this is important for the injunctions that are made against the travelling community, that when ECHR rights are engaged, they're not, normally at least, engaged on a community-wide basis. They are engaged on an individualised basis, as the Court of Appeal described it. And that's important because what it requires is the consideration of the individual circumstances quite closely in all of these cases, where injunctions are being sought, both in relation to the existing identified individuals who may be present on the land, but secondly, by the mechanisms of review that will now be in place in relation to final injunctions that are granted against persons unknown, a consideration of the personal circumstances of those newcomers as and when they may act so as to be brought within the litigation, within the injunction, applying the Gamel principle. So that's the first important point of departure between Barking and Bromley. And the second is the ability of the court, even in cases of final injunctions where the person concerned was not originally a party, so a newcomer, for them to be able to say, by making an application to the court, that they should not be bound by the final relief that was granted. Now, a couple of words. Ranjit has explained the context of the Bromley case, but the essential context was that was a claim for an injunction against the world dealing with a number of potential elements, including fly tipping, waste and other concerns such as the formation of encampments. And the judge at first instance granted some elements of the injunction, in particular those relating to the waste elements, but not the elements relating to encampments due to a number of factors and potential weaknesses in the specific evidence that was provided that are identified in the judgment. So it was against that part, that refusal to make the encampment part of the order, that the authority appealed, but their appeal was dismissed. And that led to the broader guidance in Bromley that occurs at paragraphs 102 to 108. And 3 points to note in particular, perhaps, about that. First of all, the reference to a tension between the rights of the community and trespass occurred in the context of land that was not owned by the relevant individuals in the travelling community, or wouldn't have been owned by the relevant individuals in the travelling community. And the Court of Appeal suggested, well, that will continue to be a real difficulty unless and until sufficient numbers of transit sites are provided for the travelling community to make use of. The second point, which remains supported by the Court of Appeal in the Barking case, is the need, and this is also a very important part of an evidence base in relation to individual applications for injunctions against specific sites, the need for there to be a demonstration of a level of dialogue between the relevant local planning authority and the travelling community, whether it's through liaison in a more general sense, or whether it's in relation to studies that have been supporting the planning department, like those that go into the evidence base for the local plan, the GTAA and so on, or whether it's more specific relating to the particular families that the authority is seeking injunctive relief against. So that's the second point there. And the third point, which the Court of Appeal again endorsed as part of the guidance from the Bromley case, is that if an authority is considering seeking a precautionary injunction, then engagement at that individual level remains of the utmost importance. So that was the phrase that the court used in Bromley. And so the emphasis moves again to the idea about the importance of there being welfare assessment of the particular individuals who are on site, and especially in relation to children, where injunctions are being sought against particular sites. And so when one translates that into what needs to happen in practice, where injunctions are being sought in relation to individual known occupiers, and when there's consideration of any applications to set aside final relief that might have been granted, the court will be interested to see the nature of the assessments that have been made. They should be in writing. They should be completed by someone with training in the field. They should ensure, if they're in a pro forma or otherwise, that they deal with all of the issues that typically arise in relation to this area of law, dealing with social issues that the community may be suffering locally, issues in particular in relation to education, whether that's in the adult members of the community or in the children, and in particular the potential stability or otherwise of their education and health needs, again, both in adults and children. And one of the things that the court is often very interested in, so it's helpful for local authority evidence to be specific about, is whether or not any of the information in front of the authority demonstrates a specific and pressing need for the travelling community to be at a particular location for a particular time, and if so, for how long. That may well be dependent on circumstances, whether or not a particular operation is required, whether or not there are particular examinations that are being undertaken, and so on. So not only can specific areas of questions be identified, but also specific periods of time that may be important. One of the things that authorities are entitled to do in these kinds of cases where inquiries are being made is to ask for primary evidence in relation to those issues. So it's not objectionable per se to ask for sufficient evidence by way of medical records when addressing health issues. And it's not objectionable as a matter of principle to ask for correspondence relating to school placements and so on, and the efforts that have been made, and whether or not there's a particular special need that needs to be catered for within a particular school environment. Another thing that can be requested perfectly properly is evidence in relation to the nature and extent of any roadside existence in the recent past, whether or not the relevant family have access to other assets. And it's important, especially when pro formas are being used, that even if those questions have been asked but have been subject to a negative answer, or someone has refused to give an answer or refused to give a complete answer, that the form should nevertheless record that for matters going forward so that the court can see precisely what's happened. Now, in terms, moving back to the specific guidance that was given in Bromley and then how it was treated within Barking, we can see that 6 particular considerations were identified for looking at in terms of deciding whether or not it was appropriate to grant an injunction against persons unknown, and if so, in what terms. Firstly, the nature of that measure as being an exceptional measure because they tended to avoid protections of adversarial litigation. Secondly, that there should be, as I've said, a more general respect for the travelling community's culture insofar as those factors were capable of being realised in accordance with the rule of law. Thirdly, a suggestion that the clean hands doctrine might actually require local authorities to demonstrate they had complied with their general obligations to provide sufficient accommodation and transit sites. So harking back to that issue about the sufficiency of transit site provision. The observation that borough-wide injunctions were inherently problematic and potentially became more so as neighbouring authorities sought similar relief in relation to those kinds of encampments. The idea, which has been carried forward by the Court of Appeal in Barking specifically, that it will be sensible to limit the time period of final injunctions, and a period of 1 year with the prospect of subsequent review was suggested there, and that's something that was carried forward in Barking. But of course the 1 year is a guidance period. It's not necessarily appropriate for all circumstances. There may be occasions where it's appropriate to look for a shorter period of time, depending on whether or not there are likely to be changes in the provision of sites and so on. Equally, it may be appropriate for there to be a longer period of time if, for example, it's obvious that a site deserves a particularly high level of protection because, for example, it has national planning designations, potentially international planning designations. And so the idea that it might, as it were, not need protection from that kind of incursion in the future is likely to be much lesser. So another point Lord Justice Coulson made was this point about community that we've discussed, and it's set out there in full on the slide. But it's important to note the force with which that point was made within the Bromley case, because it wasn't something that was endorsed later by the Court of Appeal in Barking. We can see from what was being said there that really final injunctions against the world should only be taken when all the steps noted above in relation to potential provision of transit, all of the other precautions have been considered or taken, and a local authority reaches the considered view that there is no other solution to the particular problems that have arisen or are imminently likely to arise. Now, that stricture has not been carried forward into the barking guidance, whilst it's clear from the recent Court of Appeal judgment that injunctions that are wide and of this nature will still be considered to be exceptional. The court has been very careful to, beyond that, not prescribe too closely what the circumstances are that might be taken into account in demonstrating exceptionality. So to go back to an example that I was just giving, one of the things that might well weigh very heavily with the court in relation to exceptionality might be the nature of a national or international designation that land enjoys. Equally, it might be the level of harm that might occur if the protection of an injunction wasn't put in place. All of those things are in principle capable of elevating a case so that it becomes one of those exceptional cases where broader relief is proportionate and justifiable. And so the next couple of slides deal more specifically, in ways I've already indicated, with the Court of Appeal's approach in barking to what was said within Bromley. And the first is the point about the HRA being individualised. And I've covered that point, so I'll leave that slide for people to consider. But we've got the reference to where it is in the barking judgment at paragraph 105. And then in relation to the community point, again, if one looks at paragraph 106, of barking, we can see, as I said, that the Court of Appeal doubted that Lord Justice Coulson's guidance in relation to that point was correct, but it didn't doubt the guidance, and we can see this from paragraph 107, in relation to the importance of maintaining dialogue, the importance of consideration of the welfare points. And the court, as I indicated, specifically agreed with the idea of review within a time period, and gave the suggestion of 1 year as at least a starting point, and indicated that would be good practice. And so one can expect that where injunction orders are being drafted in the future, it will become commonplace for proper mechanisms dealing with review to be incorporated into those kinds of relief. So those are my observations in relation to the kinds of final orders that can be made, and drawing some distinctions between the circumstances where the order is intended to be a very broad order and those circumstances where the exceptional case can't be made out, and therefore it's important to look at the sites on an individual basis, and important to look at least in relation to those who can be identified, their circumstances on an individual basis. Now, when we come to the issue of service, because of the cases as Ranjit has outlined, the issue of service is still a critical feature within the process for successfully pursuing injunctive relief. And the first point to note is that, of course, without a demonstration to the court's satisfaction of sufficient service and, in all probability, knowledge of service, committal proceedings may be difficult to pursue, certainly difficult to pursue to the extent where a sentence may be passed that is thought to be a sufficient deterrent to members of the travelling community who are otherwise set on causing breaches of planning control on parcels of land. And in terms of the way that this is dealt with in the Barking case, first of all, there is a discussion in relation to the practice direction, the rules that deal with service, at paragraphs 115 to 117 of the judgment. So it's very helpful that all of that is covered, because those are rules that are dealing specifically with the correct approach to section 187B. And the point is made that in this respect, the essential approach under section 187B is no different to the approach under section 37, so covering all the broader ranges of cases that Ranjit identified earlier. And one of the reasons that's helpful is because when you're looking at cases where you want to apply by analogy what has been sufficient service in a different context, then those cases can by and large be applied to the section 187B jurisdiction. See also, in particular, paragraph 117 of the judgment, which sets out the efforts that must be made to identify otherwise anonymous persons unknown. And Ranjit went through those earlier in the detailed slide about the potential use of photographs, vehicle registrations, and so on. But it's important to emphasise all of those in relation to injunctions that are sought under section 187B, precisely because the courts are becoming, perhaps as a result of the judgment of Mr. Justice Nicklin, becoming more acutely aware of the steps that an authority has or hasn't taken to identify individuals who otherwise might fall more easily under the umbrella of persons unknown. There appears, as a matter of practice, to be an increasing expectation that local authorities will really take as many steps as are properly open to them to try and identify individuals, even when they may be reluctant to provide information relating to their identification. But when all those steps have been taken and no success has been achieved in that respect, then that's where alternative service comes into its own. And of course, it is a typical feature in cases of this kind, where individuals are often reluctant to provide information, and the courts are routinely ready to authorise alternative service so long as the evidence base is there to satisfy a judge that the issue has been conscientiously considered by the relevant authority and that they've done what they realistically can do. And sometimes that will be within very limited periods of time if the injunction is being sought on a without notice basis and so on. So courts are realistic in that sense. And if all of those things have been done and the evidence explains why, then there is no bar, as it were, to getting the order for alternative service. And as Ranjit pointed out, in terms of what alternative service is still indirectly designed to achieve, albeit by not relying on strict compliance with the rules, is to get to a position where there are reasonable grounds for believing that the method of service will bring matters to the defendant's attention. So, for example, where a gypsy and traveller site is being used and alternative services by way of notices being posted and other various steps, then that's still with a view to attempting to ensure that a defendant at least has a reasonable opportunity to find out the nature of the claim and indeed any order that has been made against them. So just going on from that, there are two specific purposes that are being dealt with by the issue of service. One is the need for there to be compliance with the requirements under the civil procedure rules or the specific order that's made by way of alternative service. And the other is a more tactical dimension, the idea that, of course, that the purpose of having the injunction there is primarily for its deterrent effect in the planning law world. And so the more likely it is that a person can be shown to have been aware of the proceedings, aware of the order and aware of the potential consequences of the order, so on any application for committal, first of all, so it is more likely that the court will find that there has been a breach of the order, and secondly, it's more likely to be ready to impose a severe sentence in appropriate cases. So bearing in mind that tactical dimension to service, one of the things to consider is the idea of cumulative approach to alternative service, and sometimes going beyond what might be required by the court order. And there are a number of ways that this can be done, and they're all supported by relatively recent authority dealing with different methods of service. Of course, email can be used as part of the cumulative approach. The use of text messaging with a series of text messages setting out the essence of an order and its consequences has now been supported in case law. There's a case called LJY decided in 2017, and for those who would like the reference, it's EWCA 3230, a Queen's Bench case. That's dealing specifically with text messages. And then again, more recently than that, the idea of using WhatsApp as a messaging system to ensure that orders are communicated. And that was dealt with in a case called Gray and Hurley, which was decided in 2019, EWCA 1636. Another point about service and trying to deal with these kinds of things in a more regular way is the importance, where there are solicitors who are acting on behalf of defendants, of actually ensuring that they take steps to put themselves on the record, which they won't always do of their own account. So where there are solicitors acting, very important in appropriate cases to chivvy them up so that they do actually put themselves on the record, because that has very important consequences in relation to the sufficiency of serving documents on the solicitors. Equally, even where solicitors aren't acting, if there are other agents acting, such as planning agents, then it can be well worthwhile making sure that materials are provided to those agents who can be expected to be in communication with the individuals who are on site. And so, returning to the Barking case and some of the principles that were being applied there, Ranjit's dealt in detail with the Court of Appeal's central reliance on the Gamel principles and their correctness. And the reason that that's particularly useful in terms of planning injunctions is, of course, because Gamel was a Section 187B case. And so to the extent that the Court of Appeal relied on that case, it's giving a very direct authority for the propositions that are set out in the judgment, and really leaving Gamel entirely intact as to what it decided. The importance to the Court of Appeal of the Gamel case is set out in a number of paragraphs in the judgment. They took the time and trouble to outline the facts of Gamel at some length in paragraphs 25 to 31 of the judgment, and then relied on it specifically for a number of the findings that are made by the Court of Appeal. First of all, in paragraph 87 of the judgment, they relied upon it to support the idea that there could be reviews of final orders in cases of this kind. And in fact, that it's a misnomer to speak of the litigation being at an end when the final order is made. The litigation in these kinds of cases, the Master of the Rolls tells us, only comes to an end, in fact, when the injunction is, if ever, later discharged. And paragraph 87 was also used to support the idea that there could be applications by newcomers to vary the terms of the relief if they thought that it couldn't properly be applied to them. In 91 and 92, the Court of Appeal was at pains to point out that there isn't an important distinction between interim and final orders in this respect, and that's obviously helpful for authorities pursuing both kinds of order. Paragraph 94 deals specifically with the point that Ranjit mentioned about individuals who fall within the description of persons unknown as a newcomer by doing the act that is set out. So operational development within a site located at land X. Once a person comes onto the land with knowledge of the injunction, does that act, then they will become a party to the claim automatically as a result of that. And there's no further need for there to actually be an application naming them as a party, although of course as soon as they can be identified as an individual, then that would be an appropriate application to make. Lastly, the Court of Appeal were very clear, paragraph 96, that the judge below ought to have applied Gamel rather than the other authorities that he preferred to rely upon. And so a number of points arise from the way that the Court of Appeal relied on the Gamel principles, which are important to what the court will consider when looking at whether or not there should be a grant of a final injunction, and indeed the circumstances that might apply to a successful variation of the injunction by a newcomer. And the first is that the Porter analysis, the various factors that are outlined in the very detailed judgment of Lord Justice Simon Brown in Porter, as endorsed by the House of Lords, they deal with named defendants, because there what's happening is the weighing up in the balance of the personal circumstances that an individual might rely upon to decide whether or not there ultimately should be an injunction. And it follows from that that the Porter analysis doesn't apply in full to the original consideration of whether or not to grant an injunction against persons unknown, because by definition, their personal circumstances can't be known other than in the broadest and most abstract terms. And so, because that hasn't happened at the stage of the initial grant of even a final injunction against persons unknown, that influences what the court will be prepared to take into account when an application is made by someone who wants to vary that kind of order. So the things that the Court of Appeal indicated would be taken into account are the reasons for the injunction, and they, of course, in this context will be typically to address a similar kind of mischief, like operational development, as would have been carried out by a named party to the proceedings as well. So the nature of the mischief will very often be similar as between those two cases. The court will look at the reasons for the breach, which conceivably might be different for someone who's a person unknown compared to a person who was identified. And thirdly, they will look at both the Porter and Brown principles. Now, the reason that it's important that the court has said in terms it will look at the Brown principles is because, as those who are familiar with this area of law will know, what Brown requires is that where someone has come onto land with knowledge of an order, but then commences breaches of that order, then they start at a very significant disadvantage in any application they make to seek to have that order vary, precisely because what they've done is come onto the land and breached it in the face of an existing court order. And so it's important to see that there will be a distinction, two important kinds of distinction, in the way that applications are treated for those who come onto the site as newcomers. The way that the Porter guidance is applied will be different from when they were persons unknown, and the issue of the Brown guidance will arise, certainly in circumstances where someone only makes their application to vary after they've come onto land or after they've committed the act which was within the injunction. And so where we arrive at happily at the end of all of this is that we now can be confident that final injunctions, both of the kind against the world and indeed of those that are more specific, but which are also directed towards persons unknown as a residual category of individual, can bind newcomers. We know, applying the Gamel test, what will happen automatically and when those individuals will become subject to the proceedings. We also know, as a result of all of this, that there will likely be an increasing vigilance in the courts over the next few months, perhaps the next couple of years, to ensure that injunction orders are suitably worded and provide adequate mechanisms to protect those newcomers who may want to make applications in relation to some or all of the measures that are contained within the application. And it's worth just noting, just as a matter of fact, from the Court of Appeal's judgment, that in paragraph 10, they noted that in nearly all of the cases that had come up to the Court of Appeal for determination, there had in fact already been, within the final orders that were made, provision for there to be applications to vary or discharge. So that's one of the reasons why the Court of Appeal was apparently relatively relaxed about the idea that, well, of course, the idea that a newcomer could apply to vary because they haven't been subject to the previous processes of the court, can be something that is part and parcel of this jurisdiction. So I'm going to move finally on to just a few miscellaneous matters relating to planning injunctions that have been dealt with by the courts recently. The first is in relation to mandatory orders, the idea that injunction orders can be required to make people do specific things as well as stopping them from behaving in a certain way. And in relation to mandatory orders, it's worth bearing in mind that there are three essential touchstones to when it can be appropriate to seek that much greater level of relief, certainly on an interim basis. Quite often it can be a standard part of the approach to seek mandatory relief at the end of the case, but it can be sought during the currency of a case as well. And the three touchstones are for the court to consider under section 37 whether or not it's just and convenient for that additional kind of relief to be granted. In cases that involve any convention questions under the ECHR, they will of course want to tailor any relief that they grant to the idea of proportionality, and so they will want to look closely at what the potential implications of granting mandatory relief will be. So if it's mandatory relief requiring someone to leave the site, those questions about planning history, those questions about the nature and extent of any risk of a roadside existence arising will come sharply into focus, and so those will be the kinds of questions that a local authority will need to provide its own evidence about, so that it can assure the judge that those issues have been properly taken into account within the decision-making process, which is such an important part of the overall Porter guidance. The third way that judges sometimes look at mandatory relief is to say that there should be a heightened bar to cross, and the way that the bar is described is as being a strong prima facie case, so a stronger case than one that merely arises on the balance of convenience. But where that test is being applied, it's still, in relation to named defendants, going to be an application of the Porter guidance, albeit at that interim stage. One of the ways that local authorities can increase the chances of getting mandatory relief is to make sure that the extent of the mandatory relief is really quite tailored to what is required over the short term that an interim order might be operational. So, for example, if there has been operational development on land, a continuing prohibitory injunction to stop any further operational development from occurring may well be appropriate. What is going to be much harder to get at an interim stage is mandatory relief requiring the removal of operational development, whereas it may be an easier thing to persuade the court that someone who's come onto a site very recently hasn't really established a home there, may not have the utilities connections that they require in order to have proper living conditions and so on. And so for those reasons, it is proportionate and appropriate to have mandatory relief for them to actually leave the site. Something that's sometimes overlooked, but it really is a very rare and exceptional case where it's appropriate for it to be done, there's no bar in principle to it being done, is for an application for mandatory relief to be made either without notice to the other side or on short notice to the other side, where that can be done, but they can't be given the normal amount of notice that they would be entitled to. So there's no need to discount that out of hand if that's something that seems in a quite exceptional case to be otherwise something the authority might like to seek. Similarly, and it follows from that, as I've said, that you don't have to wait until the final hearing to pursue a claim in relation to mandatory relief. That equally can be done on the normal return date, where the defendants, if they choose to, the named defendants would be capable of attending. And just again, as a matter of practice, a word on without notice hearings. Recent experience demonstrates that, again, there's certainly an increasing tendency in the High Court to look quite carefully at the two potential justifications for taking an injunction claim without notice, the first of which is urgency. We just simply don't have the opportunity to give proper notice to the other side. And the other is what's called secrecy, but in this context is the idea that if the defendants are alerted to the prospect of injunctive relief, then they will simply carry on and speed up what has already been occurring on the site. It's now important that one or both of those limbs, if they're going to be relied upon, are really quite clearly evidenced in the witness material that's before the court, because there is, as I say, an increasing willingness to scrutinise the completeness of that evidence. And on that as well, it's important to bear in mind that whenever an authority goes without notice, there is a much increased duty of candour on the local authority to ensure that it's disclosing all of the appropriate facts, so that the judge who doesn't have the benefit of argument from the other side can really see what the substance of any points that might be made in favour of those defendants might be. So, for example, if the authority is aware of any health issues, any particular educational issues, those need to be put in the evidence. If it's aware of particular issues in relation to local need, whether it relates to transit sites or other provision, then again, that should be provided to the court so that a proper assessment can be made of those things and they can be put into the overall Porter balance. One of the reasons why that's critically important is that even if an injunction is otherwise justifiably made, then it can be a good reason all by itself to discharge an injunction if the local planning authority hasn't given proper evidence complying fully with that duty. So that's an important thing to bear in mind. Last two items, bench warrants. The need for bench warrants may arise from time to time in relation to committal proceedings, where committal proceedings are taken, but the named defendants don't appear before the court in order for the committal proceedings to be determined. And what's been made clear in the recent case of Branch is that that is a jurisdiction that's available to the civil courts in dealing with these kinds of injunctions. It's something that will normally be taken as a step, normally be done before there is any prospect of a sentence, certainly any sentence of suspended imprisonment or imprisonment being passed. And the idea is that it's essential in those circumstances for the court to take every step to try and get the defendants before the court, before a sentence is passed, with a simple warrant of committal for it to be executed, so that they can explain the position, to what extent they may accept any breach, and to what extent they may have significant mitigating circumstances. So bench warrants are there as something which can be used by the court and which claimants can apply for in the appropriate case. Branch provides comprehensive guidance as to the circumstances in which that can be done. And the key point, perhaps, well, one of the key points to take away from Branch is that there is no need before a bench warrant is issued for the court to have actually made a finding that there has been a breach of the order. That would certainly be the normal process, but the court can make an order simply on the basis that if it doesn't make an order, doesn't bring a defendant before the court, then what is happening is a frustration of the court's process because the committal is not being allowed to proceed. So that by itself can be sufficient to justify a judge in issuing a bench warrant. And then lastly, in relation to committal, those who have been keeping an eye on these types of cases will have seen that there's been a slew of recent cases dealing with committal, and amongst those is a case that spawned some other litigation as well, Basildon and Anderson, and I've given the main reference for the Court of Appeal determination in that case. One of the reasons it's helpful in terms of committal is that it deals both with suspended committal, an appropriate tariff that could be used in relation to actual sentences of imprisonment that came further on down the road in that case. The approach of the Court of Appeal to those kinds of issues, albeit in circumstances where everyone accepted that there was a flagrant breach of planning control, and a number of other issues in relation to bench warrants, in relation to how to assess evidence that's given during committals, whether it relates to apologies, whether it relates to understanding of what was likely to have been happening on the land. A number of those issues have been considered and dealt with in a relatively detailed way in the judgments that have been provided. So for those who are seeking some more general guidance in relation to recent committals, that may be a good place to start. And those comments conclude my slides. Ranjit, I'm not sure if you've been able to see if there have been any further questions posed on the chat while I've been speaking, but can I just say before I, as it were, finish my talk, thank you very much everyone for your attendance and attention.
Yes, thank you very much, Wayne. I think we've answered the majority of the questions. There are a couple that we haven't quite managed to deal with, so I apologise for that. But it just remains.
So, Ranjit, I think you may need to turn your volume up.
Is that better?
Yes.
Anyway, it remains for me, if you can hear me or not, it remains for me to thank you for attending and have a good day. Goodbye.